Hello again. Hope you are refreshed enough and looking forward to our next panel, which is dedicated to Cyber Law Toolkit. It is my pleasure to have on a stage my dear colleague Tomas and my dear colleague Taťána Jančárková, who is currently a researcher at NATO Cooperative Cyber Defense Center of Excellence. The shortcut is NATO CCDCOE. Let's stick to that. And this panel is also hybrid, so we are joined by Ms. Tolppa, Mr. Samuele de Tomas Colatin, also researchers from NATO CCDCOE, and last but not least, also by Mr. Kubo Mačák, who works at International Committee of the Red Cross. I hope we will not have any technical issues which can imitate, like ghost summoning seances. If you can hear me, give me a sign, and something like that. You know how this ends in horror movies, right? So, it is also my pleasure to welcome Václav Boravička, who is going to have an introduction for Cyber Law Toolkit panel. Vašek, floor is yours.
Can you hear me? Give me a sign. Cool. I can hear myself. Hello, everyone. I'm really glad that I can be here with you and that we were able to manage to organize this conference and to see you in face. And I'm really glad that I got the privilege to say a couple of words as an introduction to this wonderful panel. I'll start a little bit with international law itself. Back when I was at the university, I always said to myself that it's cool stuff. It's something like really interesting, and let's say the different nature from the national law and its ability to impact the actions of states in a geopolitical scale. It really fascinated me, but I've never imagined that I could actually do somehow international law. From the perspective of a young legal student, it was something far for only a limited number of experts and or scholars. But then cybersecurity came in, and to be honest, that I realized that there is a possibility to actually work hands-on on international legal issues and debates and problems which needed to be dealt with. And it actually became one of the reasons I joined National Cybersecurity Center at National Security Authority back in 2014. It was the time when the first Stalin manual was, let's say, circling around, making waves. The time when at least I could see the biggest merge of discussions on if and how international law is applicable in cyberspace. It is. It was a wild, it is still, I think, a wild time for lawyers focusing on this area and this field, considering the fact that at university we've been taught that the decades are a short period of time for international law development. So yeah, it's a really interesting issue, and as a legat in National Cybersecurity Center, I really soon realized that it's not really just about academic debates, and it's not just for scholars, but it really does have impact on how states act, how they approach their modus operandi in cyberspace, how they set up their procedures, operations, how they react on whatever attack from whatever foreign attacker. International law is really it's really important and essential element for successful and proper activities of the state in cyberspace. So this also means that, as I said, international law is not only for a limited number of scholars, but it is a business for more people. It is the thing. The international law is dealt by with a actually a number of specialists, not only in legal areas, but also in a non-legal areas, also by people who do not deal with it like every day, but they do bump into the topics from time to time from different directions. It could be professionals in law enforcement, professionals in homeland security, defense, international relations, crisis management, etc. And actually this brings me to the Cyber Law Toolkit project, which aims to overcome the gap between academia and practice, to give a hand to various professionals. The project which allows not only, as I said, legal professionals, but also non-lawyers, policy specialists, international relations specialists, or even students to understand current thoughts on how international law applies and what are the debates on the applicability of the law in different situations, in different scenarios, which some of the scenarios would be hardly imaginable years ago, but they are cold reality of today. So, as the title of this panel suggests, it was focused precisely on that, on the Cyber Law Toolkit, and which have been started by three wonderful colleagues, which happen to be here with us today, with significant contributions by University of Exeter, NUKIP, of course, CCD-COE, International Committee of Red Cross, US Naval War College, University of Wuhan, and of course all the other contributors to the project, whether on the scenarios preparation side or review side or in the board, for everyone who did contribute to this project. So not to further delay the, I believe, more interesting part, I'm glad I can hand over to my colleague Tomas Minarik and to the distinguished panel to share with you more information, thoughts, and I believe even news about the project. So thank you and enjoy.
So, thank you very much, Václav, for your very kind introduction. Václav has been following the creation of the toolkit from the very beginning, and he was participating in it as the peer reviewer of scenarios and also of some of the functionalities of the toolkit before its launch. And we are really glad to have him on the advisory board, and we hope to keep him there in the future. But without further ado, let's proceed with the panel. We'll try to fit everything in the 1 hour of time and have a nice Q&A session in the end. I will also repeat the things that Karolina said about Slido. You can pose your questions over Slido. Also, yeah, if you don't have any signal here, just connect to the Wi-Fi. And yeah, I will also provide a more introduction to the speakers, in the order that they will speak. Kubo Mačák, he's the general editor of the toolkit, and he's really the prime mover behind the project. He will provide the general introduction. He's a legal advisor in the ICRC's legal division. Prior to joining the ICRC, he worked as an associate professor at the University of Exeter in the United Kingdom, where he taught and researched in the area of public international law, international humanitarian law, and international cyber law. We also have Maria Tolppa, who has been very kind to accept our invitation as an external speaker. She's primarily a legal advisor, a practitioner. She served also as a peer reviewer of the toolkit. She works at the International Law Division in the Ministry of Foreign Affairs of the Republic of Estonia, and she advises on matters related to national and international law on cybersecurity, digital issues, and artificial intelligence topics. And last year, she temporarily joined the law branch of NATO CCD-COE to focus on some very timely issues and projects. I also have with me here my colleague Taťána Jančárková, who's the scenario editor of the toolkit. She's a researcher of the law branch at NATO CCD-COE in Tallinn, Estonia, and her current research interests include application of international law to cyber operations, protection of critical information infrastructure, regulatory aspects of 5G technologies, and she previously served as a legal advisor at NUKIP. And we also have Samuele de Tomas Colatin, who's an external researcher for the NATO CCD-COE and has been working on many tasks in the past related to the toolkit, including the major national positions feature that is added by this update. He's a non-resident research fellow at the law branch, and his research focus covers, among other, legal reviews of new weapons, means and methods of warfare, and a comparative analysis of national cybersecurity strategies. So, first I would like to pass the big screen to Kubo. He will take you through the history of the toolkit, its partners, milestones, elements, and the intended audience. So, Kubo, the floor is yours. I hope the sound works.
Thank you, Tomas. Can you hear me okay?
Yes, we can hear you great. If you want, you can share the slides yourself, or I can click through them for you. Depends on you.
I'll try to do it on my end, and you can always tell me if there is a problem. So yeah, dobrý den, Brno. Hello, everybody, and thank you, Tomas and Václav, for your very kind introductions. It feels almost like a reunion, like a friendly reunion, with the one regret that we can't all be together in one room. I have to say that I did participate in CyberCon Brno in the past, and so I regret it even more that I can't be there with you, because I know that it's a conference with really fascinating content, but also a very pleasant, stimulating, and just convivial atmosphere. So it's a pity, but hey, here we are. The COVID period has closed some doors, but it has opened many other ones. And so most of the work on the toolkit actually happened during this period, but as you will see, we started it before. And so we actually did start it by being all of us, the three prime movers, as you have said, Tomas, in one place. And so maybe I'll try sharing my slides to give a little bit of context to the history and the background of the toolkit. So let's see. Hopefully you can see my slides. Tomas, can you just give me a nod?
Yes, we can see your slides. Perfect.
Actually, I can also see a part of the big screen, so that's all great. All right, so I'm going to talk for the next about 7 minutes or so, just to give you a general introduction to the toolkit, and of course, I'll be very happy to answer any questions that may arise from this. So, what is the Cyber Law Toolkit? Well, let me share a secret with you. It will no longer be a secret, because I take it there are quite a number of people in this room. So one of the biggest debates that we actually had when we were designing the project and trying to complete it was whether we're going to call it the Cyber Law Toolkit or the Cyber Law Toolbox. And it was a great debate, and not being a native speaker in English, I didn't see the import so much. But what I can tell you now, we did side with toolkit, and so the project is in a sense a kit of tools, but if you prefer, it could be a box of tools like the one you see on the slide. And so, like any person who needs to do some home refurbishment, some home improvement, you might reach for a different tool depending on what you need. And so that's exactly also the toolkit itself. By the way, so that we're not just talking about it in abstract terms, you're very welcome, if you're holding a device in your hands, a computer, a mobile phone, to open it and just to see as we go through it. And you will also get a practical demonstration, but I just find it's easier to picture what we talk about if you can actually open the toolkit and follow it in front of your eyes. So these tools that we have in the toolkit include, and that's at the heart of it, a collection of realistic scenarios that are accompanied by practical legal analysis. So as Václav has said in the beginning, how international law applies to specific cyber incidents is now a big topic. It's an even bigger topic than when we were starting the project. And so this is the core component of the toolkit. It now contains 24 such scenarios. But it also has other parts. So for a number of its users, it helps as a primer on key international law concepts as they apply to cyber operations. So when you think about notions like sovereignty, like non-intervention, like the notion of attack under international humanitarian law, and so on and so forth, the toolkit contains brief boxes, brief analytical or even synthetical, you could say, components that provide an introduction to these notions of international law as we apply them in the cyber context. Then this year we have a new feature that Samuele will talk about more, and that's an overview of national positions on the application of international law to cyber operations. So that's in a way a new tool in the box. And then we also look at, we also have an overview of now 45 major cyber incidents. So if you think of Stuxnet, of WannaCry, of NotPetya, of SolarWinds, of the Microsoft Exchange hack, and so on and so forth, the major cyber incidents that have shaken the world over the past decade or so, you will find all of them in the toolkit, also with the links to the individual scenarios that analyze similar set of cyber incidents. And then one of my favorite features, which I just had to put on the slide, is the fancy keyword cloud that we have, which shows in a sort of relative size of the keywords how much attention is paid to them. And so you can also easily see what the toolkit focuses on. Now, who is behind the toolkit? I think I can go through this quite quickly because we have heard this already from Václav before. It should be also mentioned that we started by having funding from the UK government, from the Economic and Social Research Council for the pilot year of the project. And at the moment, the project is self-sustaining by in-kind contributions of these 6 institutions. So NUKIB, of course, the host of today's conference, the ICRC, CCDCOE, University of Exeter, US Naval War College, and Wuhan University. So you can see that basically the whole world is represented in the creation and formation of the toolkit. The people that contribute to it we don't have a picture of all of them, and that goes back to what I mentioned before, simply the fact that in the COVID period, a lot of the work has been done remotely, but the picture that I did include is from one of the workshops that we did in person, and that was the workshop at Exeter. But of course, there are now more than 40 people that have been involved in various capacity, and some of them are sitting in front of you or are in the virtual room with us today. So why do we need the toolkit? We spoke to experts from around the world. We spoke to government lawyers, to military lawyers. We spoke to cyber operators. And what came out from the survey before we started the project was that there is a lot of research work done on the theme of the toolkit, or on the theme of international law of cyber operations, but the research findings are quite theoretical. And there were some complaints from practitioners that even though it's very useful and interesting and academically stimulating, the scholarship can also stretch the legal concepts and can take them beyond what is the current lex lata. In other words, beyond what is the present positive law. And so when you're a practitioner, you of course need an answer what is permissible under the present state of the law, how does the law constrain me? And so that's why it was felt that it would be good for there to be a one-stop shop. So one resource to which you could go that would answer all of these questions. So we asked about the substantive issues, and a number of them were coming on a recurrent basis from this group of experts that we consulted at the outset of the project, like those you see on the screen. Then we asked also about what are the substantive, the technical issues that are arising. We asked, where do you feel the legal uncertainty the most? And we heard these topics like state responsibility, sovereignty, use of force, IHL, that are now these various legal concepts in the toolkit. And we also talked about specific incidents. And I didn't put them up here in detail because a lot of the discussions were held under the Chatham House rule. And so some of the incidents that were shared with us were shared on a confidential basis. But what we then did with them was we isolated the specific characteristics, the technical characteristics from those incidents, and we turned them into hypothetical scenarios. So you can find almost all of this content now in the toolkit, but not all, of course, of the cyber incidents could be publicly shared. Those that can be publicly shared are now the real-world examples that you again find in the toolkit itself. So the intersection between these 3 Venn diagrams, if you will, is where the toolkit aims to contribute. So it answers the recurring issues, tries to address the legal uncertainty and provide some legal clarification, and it also addresses those specific incidents that can be publicly shared, that are publicly known. We asked experts what the research should look like, and I'm going to spare you the details of this survey, but basically we heard that an interactive website that would be organized like a wiki, so those of you using a Wikipedia would be familiar with it, that would be organized in a logical way around discrete case studies, and that would provide a good balance between detailed legal analysis containing these real-world examples, but also refer to publicly available positions taken by states, right? Because it's states that create international law. And so in combination of this, we interpreted these answers as a demand for this wiki-style website that would be organized around scenarios, as I have just said, and that would follow this format, content, and structure that we heard was needed, where the gap, as Václav said before, between academia and practice existed. You could ask why scenarios? And so I think, all of us as humans are drawn to stories, right? If I tell you that this is the story of the toolkit, how it started when we got together, and now we are at the next chapter of it, I think you will follow it a little bit more than if we just talked about the abstract components of it. And the same goes also to the legal analysis. So all of the scenarios are in a way a story, right? They tell a story of an incident that could very well happen, or similar ones have happened in the real world, and then it analyzes it from a legal perspective. And so in doing so, the scenarios are somewhere in between an academic article and the practical analysis of an incident that has a reason. So they're somewhere in that middle. They try to strike the balance between these two considerations. And so also in doing so, we can then isolate the key aspects of incidents that happen on a recurrent basis in the world without being too tied down to the specific facts of those events. Because what you often hear is, it didn't really happen like that. And so we don't have to deal with this aspect of what is the actual evidence at hand, but we can provide legal analysis at a sufficient level of abstraction. So finally, what is the recipe for a toolkit? We started in 2018, so we are now well into the starting the fourth year of the project. We've had a launch in Tallinn at the last such conference where all of us met in person at CyberCon in 2019. We had a Chinese launch in Wuhan when the University of Wuhan joined the project as a partner, and now 2 general annual updates. So actually, and I'm going to finish with this, where are we right now? Well, obviously, we are here. It's the 22nd of September 2021, and it is our pleasure to announce the general update. And so I'm going to hand the word back to Tomas, who's going to guide us through the rest of the session when the main features of this new update will be presented to you. Thank you.
Thank you so much, Kubo. I will walk back here. And now it's Maria's turn. She, as a peer reviewer and a friend of the toolkit, can tell us what she thinks about the toolkit. Thank you.
Thank you, and hello from the rather cold Thailand. It's also very unfortunate that I couldn't be there in person. And also thank you, Kubo, for the introduction. So, working as a government official, my overview will focus on the Cyber Law Toolkit project from actually 2 perspectives, participating in it as a peer reviewer, and secondly, perhaps a little more through the aspect of working as a government official and how this project actually relates and supports and have supported what has happened and also happening in the international organizations, and also on a national level. I think that in addition to the project itself, the peer reviewing process has been given and probably will continue to give in the future a truly valuable element, as it allows to include legal experts as well as academics in the process of creating these practical scenarios that there are already so many of. Because as you can see, probably I also welcome everybody to explore the webpage and people working on the toolkit. The list itself is rather vast, having editors, peer reviewers, and a lot of other contributors from public sector, academia, and also from civil society. From a practical perspective, what I honestly consider to be extremely valuable to have been taking part of the project is that while looking at these issues through the perspective at the foreign ministry lawyer, being a foreign ministry lawyer, is how it has been able to offer to tie the current international discussions on various legal principles, as Kubo already mentioned, whether it be issues touching upon sovereignty, due diligence, international human rights law, or IHL and so forth, with vast amounts of academic research, including, of course, the insight that Tallinn Manual projects offer, but from the Toolkit projects as well, how to actually surround those ongoing political and legal discussions on an international level among experts with these practical scenarios that the toolkit offers us. Another aspect would be how to actually create supportive argumentation and statements which would allow us to present how we actually can apply these principles in practice, so it doesn't have to be all theoretical. I'm sure that some of the listeners are aware that the issues surrounding the responsible state behavior in cyberspace, which undoubtedly include how international law applies to state use of ICTs, have taken place for a very long time, mainly on the United Nations level through two working groups, which are the group of governmental experts and the open-ended working group. And by now, after 8 years of those discussions on the topic of international law, we have in place 3 consensus reports from the GGEs and 1 open-ended working group report confirming that international law applies, with some additions on legal principle, which is such as resolution of disputes by peaceful means, sovereign equality, principle of non-intervention, prohibition and threat and use of force, and of course one of the hottest topics, the applicability of IHL. Undoubtedly huge effort by experts and state representatives to be able to achieve this consensus based on framework in such a level as the UN is. However, as we can only anticipate that these exchanges will continue in the future, and hopefully more in depth, especially on international law issues, as we already have a new process in place, which is the new open-ended working group, which should end its work in 2025. And what I find here especially is where the Cyber Law Toolkit comes even more into play, because as there are states, which is fairly obvious, who actually oppose some of the areas of international law applying in cyberspace, we can tie these two sides together. We can argue based on practical legal analysis how these can and should be applied, how they affect the rights and obligations of states, and what are the current means for states to respond if violations of law happens in cyberspace as well. Also, the new additions of bringing national positions under one hat or go-to spot is very highly appreciated and a great value added, because I'm pretty sure that after the last reports came out, it will take up a lot of time for international cyber law lawyers and experts to deal with the analysis, because the last report had addition that already was 143 pages of legal contributions by participating experts. And that kind of brings me from international level to a national one, because as we can see, more and more states are publicly declaring their national views on how international law applies to state use of ICTs, which means government lawyers actually can very practically use the toolkit examples how to develop legal discussions with their counterparts and technical experts of other fields when creating these kind of positions and solutions, what state wants to say and what are these areas of international law where they want to express their views, and of course to present possible international legal implications, what they might be. And I think to sum up, I highly value the possibility to be part of the Toolkit project and actually gain skills on how to learn, how to combine both the political and legal aspects with practical as well as academic examples, how to support my own work at the MFA in the future, and very much call for other experts who are listening today and to take a look at the possibilities, how to actually use the toolkit in the work and explore ways to use these practical scenarios, because one thing is most certain, international cyber law will not be off the table for a long time in the coming future. So very much thank Kubo and the team for their efforts in that front. Thank you.
Thank you very much, Maria. I will take over from Tomas for a moment now, because it's my turn now to speak a little about Toolkit's present and hopefully the future. So, hello everyone. As it turns out, I'm the only non-resident member of the team who's got to travel to Brno. It has been such a rare occasion to actually get on a plane and physically attend a conference these days that I'm thrilled and terrified at the same time. But it definitely is a pleasure to come back to Brno, where I've spent 4 years working for NUKIP before I joined the NATO Cooperative Cyber Defense Center of Excellence, where I currently work. Just a few words about NATO CCDCOE. It's a NATO accredited organization, research and training oriented one, that supports NATO nations and its partners in building capacities in cyber defense and security across focus areas of law, strategy and technology. It's also home of the Tallinn Manual that you may have heard about, and as such is a natural implementing partner for this project. Kubo has introduced the Toolkit's history, the past. I'm here to say a few words about the present and the future. So let's get started. Toolkit was never meant as a one-off project that we would just, issue a presentation and be done with it. In fact, if we wanted to become a relevant tool and remain relevant, it must grow both horizontally and vertically. It must grow in the span or spectrum of issues it covers, and vertically also in the depth of analysis it offers and the accuracy of analysis, because as you have heard, international law of cyberspace is a living phenomenon. It expands all the time. Many more nations are coming forward with their national views on issues of international and cyberspace and cyber operations. So in order to stay up to date and reflect factual situation and scholarships, and also continue engaging end authors and users, we have designed the toolkit to be annually updated. And that's why we come with new scenarios every year. Well, the past 3 years, basically. We come with new real-life examples that have inspired and informed the toolkit scenarios. And we also try to come with new functionalities, of which you will see a practical example today, later on. As to the new scenarios that we published this year as part of our annual update, they again represent the variety and the richness of the toolkit. They range from topics reflecting the current developments and current concerns with regard to healthcare sector. The NUKIP director has spoken about the growing importance of cybersecurity in the healthcare sector, and it's not only about non-state actors but also about state actors. So that's where international law kicks in, and that's why we have a scenario on cyber operations against medical facilities, both in peacetime and in a situation of armed conflict. We also ponder about the legal implications of operations against vaccine research and testing. But we also have not forgotten more, well, not so focused activities, but actually we've dealt with the type of situation or incident that is able to affect all of us, not only those in healthcare sector or dependent on healthcare sector. Sorry, that's actually not the one that I meant, but never mind. No, so we actually dealt into more traditional, or let's say internationalist issues of state responsibility, which is one of the very difficult one in cyberspace, and we have a scenario dealing with consequences of misattribution of a cyber operation due to deception envisaged by the originator of a cyber operation. And this is the one I meant. We have a new scenario also dealing with legal implications of internet shutdowns, which underlies and stresses the interdependency of networks and systems that we may not always be aware of, and how actually our dependence on physical infrastructure in one country may very negatively affect and impact on lives of residents in another country when the government decides to shut down internet. And eventually we have, of course, not forgotten about IHL-related topics, which is also dear to some members of our team. And we discuss means and methods, or differences between means and methods of cyber warfare. I've been using a lot the pronoun we, and in fact it's not really we as we sit here or as we appear on the screen always. The scenarios are authored by a mix of people. Some of them are of our making. Some of them are written by invited lawyers whose expertise we trust and respect, and some of them, and those are the, in a way, dearest ones to us, come from a public call for submissions that we publish every year, and it won't be different. It won't be different this year. So every year we commit new scenarios through this call for submissions, where we actually gather ideas from authors all over the world. For instance, one scenario hails this year from India, another one actually comes from Olomouc. So the span is really broad, and this is the call for submissions that I've just mentioned. Just in case some of you would want to get involved, the international lawyers among you, I'm sure there are a few. So this is our current timeline. Basically, the production cycle of the toolkit runs throughout the year and finishes really in summer, just before the annual update. And it involves internal, external peer review by, again, lawyers that are active in the international law of cyber operations. And you can find more details on CCDCOE's webpage, where obviously you can also search for other interesting information on activities of the center. And the opportunities that we offer as a toolkit are first to authors, so you can suggest themes. You can write the real-world examples that kind of underlie the scenarios. You can write a whole scenario, as I've just mentioned, including the legal analysis. But we also engage people and toolkit supporters in peer review, both all legal, factual, but also technical, so that actually what we write makes sense factually and is possible technically. And then we also are always happy to discuss the toolkit and issues covered in the toolkit at various events, consultative events among states, among professionals, within context of wider discussion on international law of cyberspace. And I've mentioned that we have a new feature, and right now I will hand over to Samuele, a colleague of ours, who will tell you more about the new functionality, providing an overview of national positions available today publicly, of course, on international cyberspace, because as Maria has already mentioned, more and more states are coming forward. They're making their international law coming out with regards to cyberspace, and Sam is actually one of about 3 persons on this planet who has a complete overview of all those positions, because he's implemented. He's the main mover behind, main agent behind this new functionality, so he knows it all. Sam, over to you.
Okay, thank you, Tanya. Can you hear me properly? Perfect. I will now upload the slides. Let's see. Just a second. Let's see. Is it working?
Yes.
Yes, it seems to be working, yes.
Just a second. Okay. So I can change the slide from here. So thank to all of you for your presentation and kind introduction, and greetings from Italy, actually. So I'm virtually joining CyberCon Brno for the first time, and it is really great. Thank you for the opportunity. So I will directly dive into my presentation. So in order to be consistent with the purpose of the Law Toolkit, which is, the toolkit is a living thing, and it is an instrument in constant motion, I am now honored to present the newer functionality of the toolkit, which is the national position feature on international law applicable to cyberspace. So the new functionality allows users to explore and to find out what states have been thinking around the application of international law to cyber operations. We have noticed that states have been releasing statements on international law applicable to cyberspace with more frequency than ever before. And we decided that it was the right time to start collecting all the official positions and to organize them in a user-friendly manner. And of course, the process took a lot of time and efforts, required a lot of time and efforts, and hundreds of pages of official documents. And in order to build the functionality, each position has been analyzed, dissected, and divided by categories. And these categories are reflecting the principles of international law, which are discussed within the toolkit. As you can see, we have been able to collect, yes, from the slide, you can see that we have been able to collect and organize 25 official national positions so far. And of course, we are constantly keeping an eye on all the newly released positions. However, bear in mind that on the toolkit, you will find only official position of international law applicable to cyber operation published by state organs. So you won't find any unofficial document or how it should be styled documents. So when a user clicks on one of those links or one of those positions, this is how it looks like. As you can see, the new feature can be used to easily navigate through the various principles of international law discussed by a specific country. And in other words, users can easily find what the state is thinking about the use of force in cyber operation, legal review of cyber weapons, or the principle of sovereignty in cyberspace by just clicking on one icon and one link. So we'll give you now an example on how it looks like. Here is an example of the contents of a national positions. These are a few principles extracted from the Japanese national position, and you can see that all the passages are duly referenced. This new feature has not been created just to become a storage place of official national position. Rather, this is a user-friendly and extremely intuitive instrument that allows users to explore the various principles of international law applied to cyber operation discussed by states at the moment. The function can fit the purpose of easily kickstart, for example, our research by also providing users with the links to the official documents of the countries involved. As I just told you, we just see that all the contents have been duly and accurately referenced and extracted only from official released national positions documents. In this regard, I would like to provide a couple of recommendations about the new feature. On this new national position feature, users will find the exact wording which you have grabbed from official national documents. Okay, in transposing the text of the official documents within the toolkit, we even maintain the same formatting of the text of a national position. So, for example, if a state has written the text in bold, which means that the country wanted to emphasize a specific sentence in its discussion, we maintain the same formatting in the toolkit as well, in order to avoid any distortion of the meaning. We know that, in fact, these are sensitive topics. We know that words matter in this context, and we know that. So, moreover, we made sure that this new feature is not just working as a standalone instrument, okay? It's not just a standalone instrument, but it would be also incorporated to the already existing function of the toolkit in a smart way. In fact, many sections of the toolkit have been adjusted to welcome the new national position functionality. This becomes clear when looking at the general definition of the international law principles. As now, as you can see from the slide, they are including the references to the official national positions. And of course, I put an example here on the slide. At the end of the definition box of self-defense, users can see that all the states that have addressed the issue, the self-defense topic, in their official national position. And yes, states involved have been marked by fancy flags, really fancy flags. So thanks, Tomas, for that. And what users will not find on these new features are commentary to the national positions. We find this a really important aspect to emphasize for the moment. And it is important also to bear in mind that when users find that a specific principle has been included within a national position, it does not necessarily mean that the state is endorsing or supporting a principle of international law. Rather, it means that the state is addressing it. Is addressing that specific topic within its national position. And let's see so the last slide. I mean, of course, this functionality is a living thing, just like the whole toolkit, and it will be updated as soon as new available official position will be released. This is how the toolkit can be and remain a reliable instrument available for all kinds of users, 24/7. We hope that this instrument will also help and encourage states in their creation, crafting process of their own national position on international law applicable to cyber operation by becoming an easy tool of reference for comparison of the already published national positions, okay? This aspect is completely in line with the toolkit purpose, which is the dissemination of knowledge and understanding the legal aspects of international law applicable to cyberspace. And of course, more national positions available and uploaded within the toolkit, and more fancy flags will be present on the principal boxes. So to conclude, if you want to be always up to date on the latest national official position on how international law applies to cyberspace, and you want to find them in one single site, collected and divided into categories, this is the right place to check. We are working hard to keep the toolkit updated, and this new feature will allow users to spot the newest topics regarding the application of international law to cyberspace. So what's going on out there, actually? And why this, with this, I will now conclude my part of the presentation, and I will be happy to answer your question during the Q&A session. And thanks for your attention.
Thank you so much, Samuele, for your passionate presentation. I will now proceed with the next part, and that's a live demonstration of the toolkit. So I will now try to scroll through the toolkit a little bit just to show you how it looks and how it works in practice. I hope that the website will handle the live demo. The toolkit is based on scenarios, as has been mentioned. These are short stories to make the descriptions more vivid. based on real-life incidents, but on the other hand, no scenario represents exactly one incident in order to stay neutral and diplomatic. Yeah, when we were launching the toolkit 2 years ago, I prepared a story about a desperate legal advisor who's looking for an answer to a problem. But since then, we have seen a lot of national positions pop up, and now I think that such an example would not work anymore. So we can just imagine probably a student who's interested in cyber law, or a practitioner who needs a primer on the topic, or just a legal advisor who needs a quick reference during a meeting. And yeah. Let's say we are handling an incident that is about ransomware attacks against hospitals, just the one that we had in 2020. So there are 4 options to find something on hospitals or ransomware in the toolkit. You can either try clicking through the scenarios, which in this case could be quite easy. You see medical facilities as a name of scenario 20. You could also try to go through the real-world incidents, which are reachable through here. And here you can see the Brno incident, where there's a breakdown of all the facts, and then there's a link to scenario as well. So, and then the other option would be to go through the keywords. That's the word cloud over here. There you can see hospitals right here. When you click it, you see all the referenced articles on that. Or you can go to ransomware, click it, and see what scenarios deal with it, or what incidents there are in our database. So just to show you how a scenario looks like and how it breaks down, then you can go for scenario 20 just as an example. So each scenario has a summary at the top where you can see in like very few sentences what it's about and what legal issues it deals with. Then it continues after the contents table with the keywords which are searchable. They are created as categories in the wiki, so they appear then further down. We separate the facts from the law. So here we have the description of what the incident is for the particular scenario. Sometimes we mark incidents with tags in order to be able to better reference them further on. After that, we have links to examples, and then we follow with the legal analysis. And that depends. In this case, it depends whether we're dealing with a peacetime situation or a situation of an armed conflict. In peacetime, we usually follow the logic of state responsibility analysis. So we call it the ABC scheme. So first we deal with attribution, then a possible breach of international law, and then any circumstances precluding wrongfulness that may apply to that particular case. Sometimes the attribution or response parts are missing when they're not so important in the scenario. And these boxes here, they are transcluded through all the scenarios. So this is the statement of the law, which is general for all the scenarios. And then the analysis, the application to a particular set of facts follows below the box. So this way we can update the legal analysis in one place, and it shows up in all the pages very, very easily. And the new feature that Samuele mentioned, that's active since Monday, those are the flags with the national positions and the list of national positions addressing a particular issue. So after the analysis, I scroll really, really down. You have the checklist. So those are the most important legal questions that come up in the scenario. And then, of course, the meta pages see also. There's an automatically generated list of references, which is very practical, I think. In this case, pretty long. And then the typical things that you would expect in a wiki page, so bibliography, further reading, and contributions. And at the end, we have categories where you can click through and see what scenario deals with a particular topic. For instance, I don't know, let's see, prohibition of intervention. Yeah, here you have references to other scenarios that deal with it. So this is the practical show of how it works. And now I guess it's time for Q&A and comments. I'll try to take a look at the Slido. So, there's an interesting question from the audience. How are the cases where the law is unclear in cyber domain, or there is no consensus on the global level about the law? How are they handled in the toolkit? I guess this could be a question for Kubo to start, and we'll see whether we have more to comment.
Thank you, Tomas. And I've been following the Slido questions, and I've tried to answer some of them as we were going through the presentation. So one of the things that for those of you, because I know we are limited in time, so for those of you who have asked the question, they're all excellent. If we don't get to answering them, the toolkit also has an FAQ section. So it has been shared on Slido, but in case it has disappeared, because you know how it is with Slido, you can just find it by Googling for Cyber Law Toolkit FAQ or access it from the front page under quick links. So a lot of the questions are actually answered there. Now, this is a great one. What do we do where the law is unclear? And you know, obviously, cyberspace is a new environment, and international law, the way that it applies in this new environment is still debated, and some of the key questions are disputed. So, for example, sovereignty: is it a rule or a principle? Or when we talk about the principle of non-intervention, we know that one of the key elements or key aspects of the prohibition of non-intervention is the aspect of coercion. But what exactly it means, there is a debate about that, again, between states and also between scholars. When it comes to international humanitarian law, you know, which is where the International Committee of the Red Cross provides its expertise to the project, there are a number of questions, such as, does data constitute an object? Or what is the notion of attack under international humanitarian law? So the toolkit does not shy away from these controversies, and it's not a tool of advocacy. It's a tool for practitioners, as Maria has explained, that really use it in their day-to-day work. So when there is such an unsettled question in law, where there are two or several reasonable views taken by scholars and by states, the toolkit acknowledges that. And in its analysis, it proceeds, you know, if you can imagine it as a road that you walk down and that changes into a fork. So if you take this view, then the answer would be such and such. If you take this view, then the answer could be different. But often you actually find out that the answer is the same. So when it comes to, for example, cyber operations against medical facilities, right, states might disagree whether hostile cyber operations against hospitals on the territory of another state in time of peace constitute a violation of sovereignty, because it is a rule, or that they constitute a violation of the prohibition of intervention. But for most of such operations, you will see that there is a consensus that they are forbidden by the present state of international law, whether we are in times of peace or in times of armed conflict. So that's the answer. We acknowledge the difference of views, and then we try to show the implications of those views as they apply to the specific scenarios.
Yes, Tanya?
Thank you. I might just add to Kubo's answer that the scenarios and the legal analysis are also subject to continuous review. So as understanding of a legal concept of an issue evolves, so might also evolve, so we'll do the analysis in the toolkit. So we might expand it, we might adjust it, we might complement it by new consensus, let's say, found among the nations. Mm-hmm.
And for this, I guess the transclusion feature, so the fact that we use the box in several scenarios and it updates itself
makes
immediately,
our life a lot easier.
That makes life a lot easier, even though we still have to check when we add some new conditions or features to a particular box that also the analysis that follows in particular scenarios is still correct. So I guess that also answers another question from from the audience. Yeah. Okay, we have there's one more question. Who's funding the Cyber Law Toolkit? EU, NATO? That's probably a question for Tanya.
We rely a lot on in-kind contribution, meaning sweat and tears and blood of the editorial team and labor of our contributors. But jokes aside, the initial funding was provided by the UK governmental research grant in 2018. And then the implementing organizations have committed to provide in-kind contributions in a form of, indeed, our time, and that we can devote to work on the toolkit. Then for the authors who are not affiliated to the editorial team, there's also honorarium that we pay for successful scenarios.
Great, thank you so much. So I guess I don't want to bite into your lunchtime break too much, and so I'll thank all the speakers for their participation, for their nice contribution, and also to the audience for their questions. And yeah, thank you.
Thank you.
Thank you.
Thank you all. See you.